Hello, I'm Jo Natoli, Principal of the Rental Specialists. Welcome to our 15th video in our 15-part series on the changes to the Residential Tenancies Act that came into effect on the 23rd of March 2020. Today we're going to talk about domestic violence. The domestic violence legislation was actually fast-tracked and came into effect in February 2019. If a tenant or their dependent are in circumstances of domestic violence, they can end their tenancy immediately without being penalised. A tenant or their dependent is in a circumstance of domestic violence if they were the victim of a domestic violence offence during the tenancy. They are protected by an in-force provisional, interim or final domestic violence order, a DVO. They are protected against family violence by an in-force family law injunction, or they have been declared by a medical practitioner to be a victim of domestic violence perpetrated by the relevant domestic violence offender during the current tenancy. To end a tenancy in circumstances of domestic violence, a tenant will need to give the landlord or the landlord's property manager a domestic violence termination notice and attach one of the permitted forms of evidence. The permitted form of evidence include a certificate of conviction for the domestic violence offence, a family law injunction, a provisional, interim or final domestic violence order, or a declaration made by a medical practitioner in the prescribed form. The tenant will also need to give each co-tenant a domestic violence termination notice. A minimum notice period isn't required and the tenancy can be terminated immediately. The termination notice must include a termination date, which can be on the same day that the notice is given or a date after the notice is given. A domestic violence termination notice does not need to be given in person. Tenants who terminate their tenancy immediately in circumstances of domestic violence may have a direct impact on co-tenants. Co-tenants who are not perpetrators will have a 2-week grace period where they only have to pay their portion of the rent. This gives the co-tenants time to find a new co-tenant or apply to the tribunal to have their tenancy terminated. Tenants who are victims of domestic violence and co-tenants who are not the perpetrator in a property where there are circumstances of domestic violence cannot be held responsible for any damage to the property that's been caused by the domestic violence perpetrator. Co-tenants who are the perpetrators of the domestic violence who remain in the rental property will not benefit from this 2-week grace period and are required to pay the full amount of rent as specified in the lease agreement from the date the termination notice for domestic violence was provided. In a situation where a tenant is a victim of domestic violence and wishes to remain in the rented property, then the perpetrator's co-tenancy will automatically end if a final apprehended violence order is granted that excludes a perpetrator co-tenant from accessing the property. The tenancy simply transfers to any remaining co-tenants named on the agreement. A remaining occupant who is not named on the agreement can ask the landlord or the agent to have the agreement put in their name. If the landlord or agent refuses, the remaining occupant may apply to the tribunal for an order to be recognised as a tenant under the original agreement. So effectively what this is saying is that if there is a husband and wife couple, for example, and the lease is just in the husband's name, and if there's now an AVO against the husband and the AVO stipulates that he's not allowed within, say, 500 metres of the rented home, then he automatically loses his status as a tenant of that property. The wife who can remain at the property can request from the landlord that her name be installed on the lease as the tenant of the property. If the lease was in both the husband's and the wife's name, then the husband's name is automatically struck out and the wife automatically becomes the sole tenant of that property, and she's granted a 2-week grace period where she only pays her portion of the rent for that 2 weeks. If a final AVO hasn't been obtained, or if it does not include an exclusion order and where the perpetrator is a co-tenant, another co-tenant may apply to the tribunal to end the perpetrator's tenancy, and the tribunal will consider the circumstances of the case when deciding whether to make that order or not. If you'd like any further information about any of the new laws and how they may apply to you in your circumstances, please feel free to be in touch with our office. We'd be happy to help. Also, whether you're a man, a woman, a landlord or a tenant, if you're the victim of domestic violence, it's a serious matter and we're here to help you and we're here to support you. If you're a victim of domestic violence or you know someone who is, you're not alone. If you need help and support, I urge you to contact our office or any of the organisations who specifically deal with domestic violence issues.